Okay, let's go on the record. Cause numbers 24 DCCR 0917, 0918, and 0407 on Dalton Batiste. And sir, you're Dalton Batiste?
Yes, ma'am.
All right, and Mr. Gertz, Mr. Kelly are here for Mr. Batiste. Mr. Coleman's here. The first two indictments are murder, and then the last is for possession. There's been a motion to consolidate. Is that all of them, including the possession, or just the two murders?
Just the two murders, Judge.
All right, and so that's been on file, and you don't have any issue with that. So then I have, let me get it pulled up for the right one. With regard to pretrial issues, well, and you're both ready to proceed?
Yes, ready, Judge.
All right, Ms. Relays, you are free to go.
Thank you, Judge.
Thank you. And is there anyone else?
He's outside.
And page one, this, though, we had,
No.
Judge, may I ask you one question?
Yes, ma'am.
Do you mind if I stick around and watch Mr. Gertz ask you
No,
questions?
absolutely. And you can sit up here in the
Thank
jury
you.
box, and if you need at some point to sneak out, you can just sneak out the back door.
I
Just,
appreciate
it'll be closed though. I'll make sure I see you leave
Somebody will sneak out.
so that they can come let you out of here.
Thank you very much. I'm gonna go let him know.
Yes, ma'am.
that was in my box with my court stuff.
Oh my gosh.
I feel like that is a thing.
Would you get Mr. Kimmler and his client, please? Y'all give me just a second because, is this you as well? We've got another untestable patch on Tejuan Mac.
You know the state's position on that, Judge.
Well, I'm
I
done.
think I had a motion on file.
I think we've,
Y'all have already had a hearing,
and
Yeah.
and you ordered him to
To
do
do it.
whatever it took.
mhm.
This came
I did.
in on the 25th, it looks like.
Yep. Get ready for somebody.
Ready. George.
I'm about to,
Did you want me to reach out to probation and you just see?
you don't see either of them? All right, did you- Would you, go ahead and call the name, Tejuan Mac? And if you'll
Here this morning.
text Mr. Kimmler, and I'll do what I need to then. And then I need to know what his current bond is set at. I might can figure that out.
Mr. Mack is present.
Okay. Let's see where, Mr. Mack, just have a seat in the front row right there, please.
I think Mr. Kimura had something in Judge Stevens' court.
You want me to go try to grab him?
Yes, please. And if I need to, I can run over there and just tell him real quick. I need him literally for 2 minutes. So it looks like it was 100,000 with a,
This is 150, and last month with the drug crash, 124, 7,504. 50, it's just steadily gone.
so it's 150 now?
It's like the current one he's on, it's on 100.
100. I think I raised it and then I withdrew a warrant
Okay.
the last time, I think is what happened. Recall, yeah.
Okay. That's what's, yeah, I'm sorry, Judge, I said that.
I see that now too. While we are waiting on Mr. Kemmler, let's go ahead and do what we can, and then I might just need to break for a second.
He is not next door, Judge. I'm checking the drug court right now.
Thank you.
So he's arguing with me right now.
He is.
I told him to come on.
Okay. All right. So a couple of things. Let me get this pulled up right. Too many things going on. Mr. Batiste. Okay. For any pretrial that we need to take care of before jury selection this afternoon,
I don't recall if you granted or not the state's motion to consolidate those two murder cases.
She did,
I believe I did, but if not, that is granted.
and we're in agreement to that.
And that's to consolidate 24 DCCR 0917 and 0918.
And just for the record too, just our rationale, because sometimes you do want to object to that, but here it's our position that this is a novel case, and these, whatever happened or didn't happen, happened to both of these same people at the same time, the same course of conduct and everything else, and so there's no rational defense strategy that I can come up with to object to that. So.
All right, thank you. The state filed a motion in limine.
It's a garden variety motion to limit. Judge, there is one thing I may want to just highlight with this particular case is the notion of arguing in any way or form jury nullification. That this, with this being a new law, just.
All right from the start, the judge is juggling 3 different indictments. Notice how she calmly confirms each one. This sets the tone that she's in full control, no confusion, no delay. This courtroom runs tight.
I don't know if.
I'm going to get to that in just a second. Let's go through.
I've never argued that before, and I know that I'm not allowed to argue it, and so I wouldn't.
Well, and I think there's some differences in what we're going to deal with, because I think there's some difference in opinion as to how to read the statute, and there is no guidance on that. So I think there's going to be not necessarily obviously I'm not going to allow a jury nullification. Different reading of the statute, however, without any guidance for me, we'll talk about in a minute. So let's go back to the motion in limine that was filed back in 2024. Mr. Gertz, do you have any objection to that motion?
No,
The
Judge.
state's motion. So I will grant the state's motion in limine. Obviously, if either of you, if anything's covered, I want that to go kind of both ways on what's in there. You both know, just approach me. We'll take up anything that's included outside the presence of the jury.
There is one thing that just popped into my mind, judges. I don't know that it's appropriate for there to be even a discussion about this being the first time that this type of a case has been brought.
Hold on, let me get I'm still on motion in limine.
Yes, ma'am.
We're gonna get there. I'm printing that order on the limiting. Okay, I'm getting the easy stuff first. Second, I see that Mr. Gertz has filed a motion to suppress phone toll evidence. I guess it's based on, it looks like there was Detective Neal in his report talked about call log or call detail or phone toll, whatever you want to call it, and that there's no evidence of a warrant. Mr. Coleman?
I will concede that there was no warrant at the time when Detective Neal accessed at the scene during the chaos of the scene the deceased victim's Matthew Crisis cell phone. He went into that cell phone and obtained the cell phone number for our deceased victim, and it's the deceased victim's right or standing to be asserted to that privacy interest, if it's asserted. Even more than that, Judge, after he obtained that cell phone number, he gave it to a DEA agent who ran the tolls. In other words, no communications were disclosed, or text messages or anything that shows the substance of those communications, just the numbers that called that number and the numbers that that number called, the tolls. Mr. Gertz in his motion conflates CDR, cell phone data records, with toll information. And I would concede that cell phone data records that contain substantive communications, the actual messages, that's a whole different ballgame. But the witness who I will call, the DEA agent who analyzed those tolls, will testify that this information comes from what she calls public source information. In other words, put the cell phone number in, and the information that comes from consumer reports, Accurate, whatever those databases are, that's what pops up when they put that cell phone number in there. It's not an invasive search. And one last thing I'd like to add, Judge, is during this entire, there's that exigency portion, Judge, and the fact that the toll records don't produce any substantive issues, and also, or communications, and also the standing that this defendant lacks with regard to the deceased cell phone. And lastly, Judge, I would argue inevitable discovery. Almost simultaneously, ID shows up at the hospital and photographs the contents of my deceased victim's wallet, which include, and we have photos that we're willing to offer in evidence, a photograph of the the victim's business card that has his name clearly printed, and it says on his business card, cell phone number, and it lists the cell phone number. So just in the alternative, I would argue that it was inevitable that law enforcement was going to get that number and use that cell phone number to get the toll messages, to figure out who was communicating.
I guess let's start.
May I clarify?
Hold on. I just want to start at the beginning, because if there's no standing and there's no one to argue, I guess let's start at standing to file the motion.
I don't care about Matthew, is who he's talking about. I don't care about Matthew's cell phone information. That I certainly think was inevitable discovery, and even if it weren't, they went and got a warrant for his actual cell phone. They, as quickly as they could, they went and got warrants for the two boys that were in the hospital, one of whom eventually died, and the boy that died at the scene, the young man that died at the scene. Not talking about those issues. My issue is Detective Neal gets a hold of the phone number and somehow starts in his report. You see him switch over and says, Dalton's phone is at this location from this period to this period. That's what I'm objecting to, because there's no warrant for that. I don't care about Dalton's phone number called this phone number, because they could get that off of another cell phone. Got it, no problem. My complaint is about CDR location, and clearly from his report, Detective Neal had that information and did not have a warrant for my client's information. And it's very narrow what I'm talking about.
Yeah, if there's any information about.
Here's something subtle, but serious. The judge brings up an untestable patch. That means a piece of evidence can't be verified scientifically. Sounds small, but moments like this can blow a hole in the prosecution's case later on.
The defendant's location from a phone.
Not in the toll records, Judge.
It's where Matthew Neal says he got them.
Well,
and there's no other records.
I'm not going to elicit that testimony from Detective Neal, but at the juncture when I put on Carmen Morgan is the DEA agent who analyzed the toll records, all I'm getting out of her is what numbers my deceased phone called and what numbers called his phone.
So with
her testimony.
So with regard to specifically any information that was obtained about the defendant's whereabouts based on a phone search, were there any warrants? Not warrants. Were there any search warrants done on the defendant's phone that would give that information?
Ultimately, yes, ma'am. And I'll put on testimony. I plan on putting on testimony pursuant to the search warrant that we obtained.
The search warrant that we're talking about that ultimately got to his phone was long after he had said, he's at this location, he was here this long, we know he's the guy, and that's how they zeroed in on him. Now, it was the conversations, but the big problem is there's a real specific time and location, and they had access to that, and they got that information illegally. And so, warrantlessly, let's call it that. And so, if you read the chronology of Detective Neal's report, that's my problem, is he's saying, well, we know it's Dalton and not the cousin, Howard, who was really the conduit for all this. We know it's Dalton because Dalton was at the address where this occurred. Well, that was before Dalton was picked up. It was before his cell phone was in hand.
The office report the report may read that way, Judge, but the toll information could not have given location data.
So we're talking about two different things.
Yeah.
So the toll information is going to, according to you, is going to come in and say, calls in, calls out, not substantive,
I don't have any
anything like
objection
that.
to There's no problem with
And
that.
that was obtained from the decedent's phone.
Right.
Right, and I don't have any objection to that at all. I'm not,
Well, that's what the motion to suppress says.
I'm sorry. So I think Detective Neal is using the phrase phone tolls, and I think he's wrong. Phone tolls is something we used to have back in the day where you look at just the call logs.
So here's what I'm going to say. If there was any search of Mr. Batiste's phone prior to, or not just his phone records or location or anything like that, prior to a warrant being signed, search warrant being signed, then any evidence of anything that happened before a valid search warrant is off limits. And so with regard to that specific issue, I'll grant the motion,
And that's all we're at.
but very limit to anything that came off of Mr. Batiste's phone prior to valid search warrant.
Yes, sir.
Okay. I'm going to need to probably figure out how to,
And then, Judge, I'll say if there's other evidence.
I don't see an
location-
order.
Sorry?
I don't see an order for this motion. I'm just going to write on the front page. I don't see that there was an order filed with the motion to suppress. Give me just a second. If I just do it on the front page, you can. Okay.
Whatever you want, I will make it.
Okay, the way I just wrote this was I granted the motion specifically with regard to any location data received from the defendant's phone prior to a valid search warrant. Is that clear
Yes.
enough? Sorry. Okay. It looks like there was a certificate of analysis filed. There was an objection to that. That looks like it was timely filed.
I'd like to address that if I could, Judge.
Sure.
There was actually 3 certificates of analysis filed in this case, 2 of which were filed some time ago and relate to the lab blood work on my 2 deceased victims. Those, as I understand it, are and remain unobjected to. I recently filed a certificate of analysis with regard to some punishment evidence, if we get there, on the possession of marijuana. That's a felony case, the felony cocaine case we have. And I will concede that Mr. Gertz timely objected to the possession of the marijuana certificate. In fact, he specifically referenced the lab analyst who did the analysis.
Okay. So it looks like there was one filed back, a certificate of analysis, June 20th of 2024.
Those are just the NMS.
NMS and
You don't have any issues with those?
RMP labs, Judge. Just want to make sure
Okay.
that we're
But
clear.
those are autopsy-related,
Yeah.
heart blood.
Okay,
I don't
so y'all
care
are on
about
the
that.
same page as far as that goes. I just want to make
Yeah,
sure.
I guess I didn't look carefully enough at Mr. Coleman's.
This is rare, both sides agreeing to consolidate 2 murder indictments. Normally, defense lawyers fight that tooth and nail because it doubles the risk for the defendant. So why agree strategy when both crimes are connected? Separating them could confuse the jury.
Subsequent certificate, I was anticipating it being a certificate for something, a physical thing that was found.
Okay,
So,
so we're on the same page as that. I have election as to punishment that's been filed if there is a finding of guilt for the jury, correct?
yes, Judge.
All right, so then I have the issue with regard to Mr. Gertz has filed a bench brief regarding the mens rea in this case. I've done some of my own research. Mr. Florence has done some research. I think we're all in agreement that some of the issues with regard to mens rea and specifically how it applies to the specific statute with regard to fentanyl murder I think there's probably some disagreement on. There is no case law. There is nothing for me with regard to stating what, I guess, I may have my own personal feelings, but legally what it means. So here's where I am on that. I don't believe that it does any good to discuss with the jury that this is a new law. And so I am going to, on my own, limiting both of you to say that we're not going to say this is some new case and we don't really know and y'all get to decide and whatever. It's the law is going to be what the law is. Y'all know how I do my charges. I take things straight out of the code. I'm not inclined to deviate from that. What I'm not also inclined to say now what I'm going to do later in the week in a charge. A lot of that depends on evidence that's presented throughout the case. I understand that which part of the knowing definition I put in could matter, but I don't, and I know you had mentioned that there's three. I don't know that I agree that there's three options. I think there's two options, but I have had cases, and y'all all know I've had cases where I put the first option, I put the second option, and there are cases where I put the entire definition. And so I think those are things that we take up at the normal time.
That's fine. The reason I did this was I wanted to put it out there so we can be discussing it, Judge, because I think that to me the biggest issue is going to be it dictates how we try this case.
Now we're diving into one of the hottest topics in modern law motion to suppress evidence. Basically, the defense wants certain phone data thrown out because the detective may have accessed it without a warrant. That's a Fourth Amendment landmine right there, privacy versus justice.
If it's going to be a strict liability thing and I just happen to sell something and that something happened to have fentanyl and then, well, there's that word is meaningless then. It might as well just be an act and a result. And
I mean, I can.
So, I guess the point I'm making is,
yeah.
I'm saying, I'm not trying to launch into an argument. I'm saying it makes a difference in how we try the case. Not necessarily the three options. It makes a difference if it's strict liability or not. And I don't think you're going to find anywhere in the code that it says.
No.
Well, Judge, if I could respond really briefly.
Sure.
I think a plain reading of the statute is all we need, Judge. It simply says knowingly deliver fentanyl or substance containing Group 1B that results in the death of an individual.
I agree with that for the charge.
The straight definition of knowing and intentional means consciously engaging in that conduct.
It does not. It means all three of those things. I spent a ton of time on this weekend. This Texas Court of Criminal Appeals lays out what the three things are, and they're just different from each other. And I never thought about this, as I told you before. I'd never thought about them being three instead of two, but it really is three, and they really mean something different.
Well, intentional
is not an issue.
It's not an issue.
Knowingly is the issue.
Knowingly is the issue, and whether or not the statute reads that the defendant knows or had knowledge that what was delivered or manufactured had fentanyl in it or not. My reading of the statute is that, and not just my reading of the statute, I have legislative history that I have looked at and Mr. Florence has looked at. I don't believe that in my opinion.
Pay close attention to what the judge is asking, standing in simple terms. Can this defendant even argue that his privacy was violated if the phone belonged to someone else? If the answer's no, this whole motion collapses in seconds. That's the razor's edge of criminal procedure.
That they would have created a whole fentanyl murder statute without the requirement that the defendant had knowledge that it was fentanyl. That's where I'm coming from on this. I understand that there is a difference of opinion, but I don't think it's appropriate necessarily for me to make that call. I think the definitions and the statute says what it says. And the problem is if I put the entire definition of knowing, I guess that is where you guys will run into issues, is which definition if it's the first part, the second part, or both.
And this is the last thing I'll say with the court's permission, Judge, is
Sure.
I think the knowingly goes straight to it modifies or goes to the word.
And there it is, the judge delivers her ruling. She grants the motion, but only partly excluding any location data taken before a valid warrant. Everything else still allowed. This kind of precise ruling shows how judges balance fairness with evidence.